Good evening, everybody. It's Monday at 5 o'clock, and welcome to my show. I'm attorney Chris DeBari, and I just am here to talk to you about some very important issues that have to do with personal injury lawsuits and claims. And I picked 5 o'clock on Monday because, well, I'm figuring 5 o'clock on Friday, people are probably going to want to be having fun and not doing this. So I think I've got a good time. I'm glad you tuned in. And I just want to instruct you a little bit, give you some important information about what it is I do and what we as attorneys try to get our clients when we help them pursue a personal injury claim. Now, under Florida law and under general tort law, if you're pursuing a claim against an at-fault party, somebody causes an accident, you're not at fault or not significantly at fault, you've been injured, you may have medical bills, you may have lost wages, and you are entitled to pursue the other driver for damages. Now, your ability to do this successfully sometimes depends upon other factors besides your injuries and your damages. Depends on whether or not there's adequate bodily injury insurance, whether you're carrying uninsured motorists, whether you got the driver's license plate and he stayed at the scene. Sometimes there are factors that can make pursuing a claim a little bit difficult than other times. But the most important things that we consider are, first of all, liability. So basically, who caused the accident? And the second thing we consider is damages. Now, what are damages? What is it that we try to get for you when we pursue a claim for personal injury? Well, damages are the equivalent of your harms and losses due to the negligence of the other driver. And negligence simply is neglect. Carelessness, failure to use the amount of reasonable care that a normal, reasonable person would use under like or similar circumstances. So other drivers have a duty to drive safely, and sometimes they breach that duty, and sometimes that breach can lead to damage for you or somebody that you care about. But what are those damages that we're hearing so vaguely about when you see ads for lawyers on television? We can get you money, we can do this, we can do that. Well, what is it that we're going after? What is it that drives the value of a case? Considering, of course, that the insurance and liability and all those stars are aligning properly. Well, the things we pursue in damages come in three forms. The first type of damage we pursue is called economic damage. The second is called non-economic damage. And the third, which is the most unlikely to seek in a normal case, is called punitive damage. Punitive damages occur when the person that causes an accident's behavior is so blatantly disregarding the safety of others, or they're committing a crime, perhaps they're DUI, but their action is so bad that it warrants the court, after plaintiff's counsel makes a motion, to allow plaintiff to seek punitive damages. And at that point in time, policy limits do not apply. We're going after the other driver directly for not just the amount of their insurance, but anything above and beyond that they could be held responsible for under the law. And at that point in time, they were essentially self-insured. But the first kind of damage, the economic damage, it's the one that we concern ourselves with mainly. Economic damages include things like past medical bills, future projected medical bills. That's usually done by your treating physician or by an expert that we hire to make that determination. Other things that include in economic damages are past lost wages because of the accident. I could not work because I had to go treat with a doctor. I was not able to work for a time. I had to take off time from work to go treat. I expended my car and miles. So these are all economic losses. And the reason they call them economic losses is because an economist can put a dollar value on them and tell us what you would need in dollars today in order to have enough for what your projected need is going to be in the future. In fact, when we present our demands to the insurance company, we do a calculation based upon somebody's life expectancy multiplied by years times the amount of future care in dollars that the treating physician and experts say that the person's going to need. So that's one very important cost driver, the economic damage. Past medical bills, future projected medical bills, past lost wages, projected future loss of earning capacity, person's ability to earn money and more or less earn it the way they're earning it today. Now, you can pursue non-economic damages no matter what, but you can pursue economic damages no matter what. However, non-economic damages are a little bit different. Non-economic damages, and you may have heard these terms before, they include things like pain and suffering, loss of enjoyment of life or life's pleasures, mental anguish, pre-accident terror, disfigurement. These are all non-economic damages. And the reason they call them non-economic is because only a jury can decide if they have value. An economist can't really do that. Only a jury decides if non-economic damages are going to be compensable in a case and to what extent they're going to award money to a plaintiff who has suffered non-economic damage. Now, unlike economic damage, you can't always pursue non-economic damage. There's a limitation under Florida law. Florida's tort exemption law says that you can only pursue non-economic damages, your pain and suffering, your loss of enjoyment of life, your mental anguish. You can only pursue those things if there is a medical opinion from one of your treating doctors that says that you have suffered a permanent injury within a reasonable degree of medical probability. Those are the statutory buzzwords. Once we can establish that, we've overcome the threshold, and we can now present non-economic damages to a jury or to an adjuster in a mediation and have some expectation that there's going to be some taking of that into consideration. So those are the non-economic damages and the economic damages. And they're very, very important because people ask me all the time, what are the things that make a case valuable? How much is my case worth? Well, not an easy question to answer until we know everything. But pretty reliable indicators of that are the existence of insurance or assets, if the other driver has assets but doesn't have insurance and is self-insured, the amount of non-economic damage, your past medical bills, your future projected medical bills, your past lost wages, and your projected loss of earning capacity. Those are going to be the cost drivers of the case. Liability is obviously very important. It's important that the other driver either have caused the accident 100% or so much significantly so that any comparative fault on behalf of the plaintiff would be insignificant. The plaintiff would still recover. Now, Florida is a little different than some states. Florida uses a method whereby a plaintiff can be partly at fault and still recover. Now, some states have a law where if a plaintiff is 50% or more than 50% at fault, they don't get to recover anything. Florida's a little bit different. In Florida, a plaintiff can be 1% at fault and still recover, 25, 50% at fault, 99% at fault and still technically recover. So comparative fault on the part of a plaintiff is a possibility. It won't erase your ability to pursue a claim. However, it is going to reduce the amount of the award you receive from a jury by the percentage of fault that a plaintiff is considered to share with the defendant who caused the accident. And of course, the third kind of damage, and we talked about it a little bit before, is punitive damages. Now, punitive damages occur typically when somebody has done something that is just so reckless or so bad that it's not just negligent. They weren't just careless. They were like really, really careless, reckless, acting with disregard for other people's health and safety or even their own. In that particular situation, after the case is in litigation and we've conducted discovery and done a lot of fact-finding, perhaps deposed police officers, we then make a motion before the court, and the court considers whether or not to allow us to pursue punitive damages in a case. And when the courts allow this, this puts the insurance companies in a difficult position because they have to do what's in their client's best interests, and it often leverages the insurance company to be a little more forthcoming with offers. So punitive damages, when they can be allowed in a case, are generally things for a plaintiff that are worth pursuing. But once again, very, very seldom do they apply. Some judges will grant them, some judges will not. It just depends on the facts of how seriously bad the other driver's behavior was and so forth. I just want to take a second to thank everybody who's watching. I see that a few of my friends, Kevin Martinez is tuning in. Kevin, hey, thank you very much for watching. Fritz, Hussey, haven't seen you in a long time, man. Hope everything is good. I know that your financial business is, your new business, hope it's doing well. And I'm just happy that you guys took the time to listen to this today. So those are pretty much the damages that we pursue in personal injury cases. Those are the cost drivers. Those are the things we as attorneys pursue for our clients in a case. And you know, in having a personal injury case, even one where the money's potentially big, it's not a lottery ticket. It's something that's going to be determined by these factors and either decided upon in a mediation between attorneys, other attorneys, and an insurance adjuster, or it's going to be decided before a jury of 6 people who will listen to the law, listen to the facts of the case, and take all that information, all the evidence back into a jury room and decide what the case is worth, if anything. So that's pretty much my job. My job is to present this evidence to a jury or to an insurance adjuster and accentuate, express, and illustrate the value of the case based upon the economic damages, the non-economic damages, and sometimes even the punitive damages. But folks, thank you very much for taking the time to tune in today. I appreciate it. And if you have any questions whatsoever at all, please call me at 727-656-7852 or email me at chris@cdbinjurylaw.com. That's my website and my email. And if you want additional information, I've posted videos on YouTube, on my YouTube channel, and we'll be posting more every Monday for your educational benefit, hopefully. And folks, thank you very much. And remember my firm's motto, it's personal to me because it's personal to you. And thank you, and have a great day.